I identify myself as one of you. I am a surgeon, and in addition to being a surgeon, I am also a lawyer. Currently, I practice in the field of Medicolegal world. Since the topic is very extensive and very vast, and the time allotted is 10 minutes to me, and with a direction to restrict to the timings, I shall definitely do so. So I shall be talking about two subjects to begin with, and if any more time is left, we will enlarge it. These are two subjects for which even the Supreme Court has not yet found an answer. So it could be an interactive session with you. The first issue I will talk to you about is violence against doctors. It is extremely important for you all because as resident doctors, you are the frontline medical workers and you face these situations very often. Doctors in government hospitals face it very often, and doctors in smaller nursing homes also face it very often. More than 19 states in India have legislations on the subject of violence against doctors. In spite of it, it is the poor implementation at the law enforcing agencies that doctors become targets of patient ire and have to suffer. Day before yesterday only, I was arguing before the Honorable Supreme Court that what should be done about it. The states are a party to it, they are responding to it, and this matter also got linked up with the RG car incident. So this one which we are at the moment appearing before the Supreme Court relates to that patients and lay public are responsible for violence against the doctors. And believe me, we have placed innumerable number of examples where doctors have faced not simple violence, they have also faced death at times because of patient factors. So this was one subject, and I am open to any discussion, any points from my dear friends and colleagues. The second topic which I wish to speak to you about today is wrong filing of FIRs against doctors. I recall a time in the mid-90s, in fact that is the reason why I decided to do law. If the bill was high, people would file an FIR, go to the police station. If the patient died due to even medical factors, after all people will die in hospitals. That's the place where people will die because they come with illness. People will file FIRs. And to placate and satisfy the emotionally surcharged relatives, the police would tend to take the easier option of filing an FIR against the doctors. By which time the media trial starts, regardless of the outcome of the case, the image of the doctor is already tarnished. I can quote examples without taking names. Some of our doctor colleagues who have held position of Minister of Health in some states had to face arrest overnight for these reasons only. I recall back in the year 2000, one of the hospital administrators was arrested and a charge of Section 304 of IPC was filed against him, which means actually murder. And you know what was the reason? There was a roadside accident victim whose brother brought the patient in a rush to one of the private hospitals in North Delhi. As a matter of routine and practice, the admitting person at the counter said, 10,000 rupees jama kar dijiye. I mean, he did not know what the whole thing is about, but he knew that isko ICU में admission करना है. ये बात है आज से 25 बरस पुरानी. That fellow probably thought 10,000 रुपये नहीं है जेब में. उसने अपने मरीज को वापस गाड़ी में डाला and he took him to the trauma center at Chandgiram Akhada. By which time, because there was an abdominal trauma and there was splenic injury, the patient died. हिस्ट्री वॉज कि वो वहाँ गए थे, वहाँ 10,000 मांगे. ये पॉलिसी किसने बनाई? एडमिनिस्ट्रेटर ने बनाई. अरेस्ट करो. The doctor was arrested and was in jail. No bail was granted to him for almost 2, 3, 4 weeks. The whole of Delhi doctors were on strike. Fortunately, I was in the Delhi Medical Council in the formative years those days. I prepared a policy note for the Lieutenant Governor, who was Shri Vijay Kapoor at that time. The CP was called, and our policy said simply one thing, that before filing an FIR against any doctor in the state of Delhi, please consult a medical board, which should preferably comprise of doctors from government hospitals. If the board says that there was negligence, by all means file an FIR, but that too under 304A, which is a section of negligence. The governor was rather appreciative. He said, seems very logical. The commissioner of police agreed, and believe me, friends, even 25 years have passed, that policy still holds good. And that led the way to the Jacob Matthew judgment of 2005, where again I had filed an intervention application on behalf of the Delhi Medical Council. So the policy laid down by the Honorable Supreme Court is very clear, that no FIR shall be filed against a doctor without the opinion of a medical board. So the first round of immediate arrest has got diffused. And that too, FIR will be filed under 304A, and certain directions were passed to the National Medical Commission, then MCI, to lay down a policy. Okay, we come back now to the whole thing. In spite of the fact that there is a Supreme Court judgment which continues to be in force, there are numerous instances across the country, and I have data of all these, where FIRs are filed without complying with these orders. So this is clear violation by the law enforcing authorities, और वो उनकी दादागिरी है, to be honest with you. And the worst situation was in Dausa, when in a rural setting, a lady who is a grand multipara or something, she died, and the doctor was stressed because the local police, under the influence of the politician, filed an FIR under 302, which is actually murder. And I'm sure all of us are aware of this case. Not able to take the stress, the gynecologist committed suicide. We are all aware of it. We took up this matter with the Supreme Court. I am one of the petitioners there. Last week, this petition was dismissed. You will be shocked to hear this. We said that, please listen to us. It is violation of the orders of the Honorable Supreme Court themselves. The two-judge bench said, we are not here to monitor violation of orders against our orders. If you are aggrieved, go to the respective High Court to solve it. So our last hope, for which we had filed this in the Supreme Court, was also shattered. So I am placing all this before you all, and this August gathering, including Secretary of the National Medical Commission, that how do we solve it? Let the doctors do their job, whatever they are supposed to be doing. I mean, I now stop here. I open this discussion if there are any points of view which can come about from our colleagues and from my dear friends.
So you said about the policy against doctors.
Yeah.
Center of action bill. When it will become the action?
Yeah, good. A good question, Doctor. We had filed for this, and I would like to tell you the position taken by the Home Ministry. When Dr. Harshvardhan was the Minister of Health, a bill was prepared.
I was one of the members there.
Wonderful. And the bill was sent to Home Ministry because it involves amendment of the IPC and the CRPC. So without Home Ministry's clearance, it would not have become a law or placed before the Parliament. You will be surprised. I mean, you must be aware of what happened. For the benefit of all of our colleagues here, the Home Ministry turned it down. And the reason given is that tomorrow there will be a request for violence against chartered accountants and so on and so forth. We cannot segregate doctors and create a central legislation. And to one point I agree, when more than 19 states have already legislated, it is the poor implementation of the law. Central Act will probably not solve the problem. So that issue is closed. Please do not expect any central legislation on this subject. There are not many issues pertaining to the issue of medico-legal and medical negligence. What are the options which are before the consumers? How doctors should be facing it? The Consumer Protection Act, the IPC code in itself, the current BNS, and of course the state medical councils which examine the case of professional misconduct, etc. So I close my talk with this.